Hello again, everyone. Welcome to Washington Gun Law TV. I'm Washington Gun Law President William Kirk. Thanks for joining us. Hey, we did a couple of videos. We first did this one here, which talked about this grotesque Second Amendment violation that's been occurring for decades now, involving anyone who has to rely upon federally subsidized housing, where essentially the lease agreement says, hey, you cannot defend yourself. You don't have an inalienable right of self-preservation here because you have to live in government subsidized housing. And we posed the question of, like, can you imagine any other constitutional right that was actually limited by what your tax return said? Then we followed up with this video right here about this poor young woman in Texas who was living in government subsidized housing, who actually had to defend her family and use lethal force, did so completely lawfully, only to then be evicted by the housing authority. Now, I understand that that actually is all turned out for the best for her because of all the pressure, so kudos to everyone that helped her out. Well, we're going to circle back to that first case because we talked about a lawsuit that was going on in New York, and it was a doozy. I did not realize how bad it was. Well, the government has started to respond to some of these claims, and you're really going to get your blood boiling when you hear what they have to say. So today, let's spend a few minutes and let's talk about when government dictates how you can defend yourself. Okay, so the case we're talking about yet again today, and this is the second time we've talked about this case, is Hunter v. Cortland Housing Authority. It is a case that's brought by your good friends at the Second Amendment Foundation. The issue there is, believe it or not, when you sign a lease for federally government subsidized housing, yes, there is a clause in there that flat out says you do not get to possess a firearm anywhere inside your home. Well, after the Second Amendment Foundation filed all of its pleadings and motions and all of that stuff, the Housing Authority, the Cortland Housing Authority, has now responded. And I just want you to understand that what they're basically saying is, and I will tell you this, that the arguments that they're given is the exact reason why in the late 1700s the French ran around and chopped a bunch of heads off, okay? Because it is basically like, hey, the peasants just are going to have to deal with what we say. Now, the old argument that they always used to be able to do, which is either, well, we need this to save lives and allowing judges to make balancing tests, or, well, that's the way we've always done it. Both of those arguments have kind of been thrown out on their ass now because of the Bruin opinion. And so what we're seeing is these people who are promoting civilian disarmament really getting creative here to come up with some type of arguments. And that's why we see Bowie knives equate to assault weapon bans and gunpowder storage equates to high capacity magazine bans. And you've got to see what the Cortland Housing Authority has said here. Let's just get right to what they stated. In construing the subject lease provision in light of New York's definition of firearm, plaintiffs mischaracterized the lease provision as categorical or wholesale ban. Although the provision restricts tenants and their household to the possession of firearms on CHA property, what is a firearm under the lease is not as broad as they assert in their arguments. Under the lease agreement and New York's definition of firearm, tenants may possess rifles and shotguns on CHA property without incurring a breach of the lease, as well as other traditional hunting weapons such as a crossbow. Okay, did you get that? So what they're saying is, no. You can possess rifles, shotguns. Heck, you could even possess crossbows, and we know how effective crossbows are when trying to defend yourself from a home intruder. But handguns, yeah, that is the thing that you cannot have. Let's see, what was the case that talked about an outright ban on hand? Oh, that's right. That was the Heller case. Now, there's more to their argument, though. I want you to check out what the Housing Authority further argues here. Plaintiff's assertion that CHA has a categorical ban on firearms, which is the keystone of their arguments, is incorrect. The CHA restricts tenants from possessing some types of firearms on its property, but does not, through the subject lease term, ban all firearms. Now, this is where, of course, the Housing Authority has to get really creative now because they have to come up with some historical analogs. And creative they were, offensive they're even more. Check this out. Here, there is a historical regulatory analogy between the RLA provision and PHA's limiting who may be part of a tenant's household, which affects a tenant's fundamental familial rights. The concept of the fundamental right of a family is as deeply rooted in this nation's history. Any regulation that impacts an individual's right of family inherently concerns the activities that occur within one's home. There is a close analogy that can be made between the governmental regulation of family within one's home and a restriction of firearms in the same. Did you get that? Did you get that? That is exactly the arguments that they are making. This is the dystopian regulatory arguments that are coming from those now that are supporting civilian disarmament. But wait, there's more. With respect to a PHA tenant's fundamental right to family, HUD and PHAs regulate whether certain members of a family may live in a public housing development. Specifically, members of tenants' family that demonstrate a pattern of alcohol abuse, engaged in drug-related activities, have used illegal drugs, or are registered sex offenders are all subject to immediate eviction or denial of public housing developments. I should point out that none of those activities are constitutionally protected. In fact, each and every one of those is criminal in nature and repugnant in its origin, but they go on with more. These law regulations impact a tenant's fundamental right to family, more particularly the right for a family to live together. Similarly, the lease provision limiting certain firearms from its property, including tenants' residence, should also be upheld based upon the historic analogy of the government limiting the equivalent fundamental family rights of individuals in public housing. That's right. They want to equate you owning a firearm for purposes of self-defense, or as I like to call it, self-preservation, to abusing drugs, abusing alcohol, being a sexual offender, being a domestic violence perpetrator. They believe that because they can evict certain people from their housing for committing all sorts of horrible criminal activities, that they have the right to do so as well because you exercise an inalienable right. Okay, listen, I know this seems rather shocking, but no, that is actually how they pled this case. We will link the pleadings up down below so you can see for yourself. The case, once again, is Hunter versus Cortland Housing Authority. It's brought to us by our good friends at the Second Amendment Foundation. Kudos to everyone over there. This is an incredibly righteous fight. If you want to show Second Amendment Foundation some love, we'll put a link down in the box for you to do that as well. Now, in the meantime, let's everyone remember that part of being the lawful and responsible gun owner, like we talk about all the time here, is to know what the law is in every situation, how it applies to you in any instance that you may find yourself. Until next time, thanks for watching and stay safe.